On behalf of Judges Odenwald, Page, and myself, I'd like to welcome you, and you as a unique definition today, because there's the people who are in the room with us and the people who are watching the argument on live stream. I want to thank all of the parties and their attorneys for accommodating this special setting. We have limited the courtroom to 10 people per government orders, but we are an open court, and that's why we're live streaming today, and we will subsequently post today's argument on YouTube. I would like first Appellant's counsel to approach the podium. Please don't touch it, because we're not going to sanitize between this aspect of today's argument. State your name, please, the party you represent, the amount of time you wish to reserve. By special order, today's argument is 30 minutes per side, with 6 minutes for Appellant's rebuttal.
Good morning. My name is Tom Weaver, and I represent the appellants Johnson & Johnson and Johnson & Johnson Consumer, Inc., and I will be requesting the full time this morning, the 30 and 6.
Okay. Thank you, Mr. Weaver.
Thank you.
30 minutes and 6 for the respondent.
Good morning, Your Honors. I'm Kevin Parker from the Lanier Law Firm in Houston, representing all of the respondents this morning, and I will also request the full time, 30 minutes.
30 minutes. Thank you, Mr. Parker. Mr. Weaver, you may proceed.
Good morning. Thank you. Again, my name is Tom Weaver, and I represent the appellants Johnson & Johnson and Johnson & Johnson Consumer, Inc. I'll be referring to them as J&J and JJCI. First of all, I'd like to thank the court for accommodating us and allowing us to have this argument in person in these difficult times. We very much appreciate it. Confronted with dozens of epidemiological studies resulting in scientific consensus that talc use does not cause ovarian cancer, and without any real scientific evidence of general or specific causation, plaintiffs pursued a mass trial of the claims of 22 families from all over the country, only 5 from Missouri. They used the sheer number of plaintiffs to persuade the jury that talc use must cause cancer.
Mr. Weaver, how do we know that? How do we know that that's what the jury did?
We know, well, we know how the trial was, how the case was tried by the plaintiffs, which was to consistently emphasize the number of plaintiffs who were there, consistently present the plaintiffs as a collective or as a group, and then.
But how do we know what the jury was thinking?
Well, you know in part what the jury was thinking by the fact that after a 6-week trial, they deliberated for slightly longer, a little bit more than it took to read the jury instructions, to return verdicts where they awarded the exact same damages to every plaintiff family, whether that plaintiff family consisted of one person, the woman who had the ovarian cancer, the woman who had the ovarian cancer, and a spouse who was seeking loss of consortium, where the damages were divided equally, $12.5 million by each, and then in a third case where there were 3 people who were receiving funds, and it was $12.5 million to the woman and $6.25 million to the other 2. Can we know exactly what the response of the jury was, what everyone was thinking? No, you don't. Obviously, you can't get into that because you're not allowed to interrogate the jurors. But what you can look at is the way the case was tried. You look at the issues that were raised prior to trial, the concerns raised by the defendants in their motion for separate trials, which is document 3490, which lays out all the concerns, and each one of those things that they expressed concern about occurred during the trial, and including the fact that a concern that the result of the multi-plaintiff trial was going to be higher verdicts than were awarded if these cases were tried individually, which is exactly what happened. The $25 million awarded here was between 2.5 and 12.5 times the amount that had been awarded in all the other, in the 4 cases previously tried as individual claims in the City Circuit Court. So I don't think, Judge Hess, it's fair to suggest that you have to know exactly what was in the minds of the jurors, because you can't talk to them and find out, but you can look at the record and see a consistent pattern from start to finish. In fact, starting before the trial even started, when plaintiffs were responding at the hearing on the motion to sever, which is transcript page 111 to 114, where after being confronted with the argument about all the differences, the plaintiff's counsel's response was, yes, there are a lot of differences, but the important things are all in common. Same defendants, same product, same disease. And that was the theme that was pursued throughout the trial. And again, the plaintiffs presented their case not as individualized claims, but as a group or collective claim, constantly asking the jury to compare these plaintiffs and the circumstances of these plaintiffs.
So if I could ask, and going to your first point on appeal then, with regard to the denial of the motion to sever, is the concern that the cases weren't severed and tried separately, or is your real concern over the way the evidence was presented? It seems to be, as I read through the brief, you felt this wasn't a fair fight, that the judge allowed in a lot of evidence that should not have been allowed in. You call it junk science. And so is the real concern over how the case was tried? If you felt there had been a clean fight, would it have been a problem to have tried those 22 together?
It could not. You could not have a fair trial trying these 22 plaintiffs' claims together. However, it was tried. The prejudice inherent in trying 22 family claims together is inescapable, regardless of how it's tried, because you have the fact that you're going to have a jury every day, as they were in this case, confronted with a courtroom filled with women who have ovarian cancer, or the families of women who had ovarian cancer and died. You're going to be confronted with the fact.
But all mass torts cases have that, and so aren't what we're supposed to engage in, the trial court is supposed to engage in a balance of the potential prejudice versus the reasons why it may benefit having these cases tried together? I mean, and so if it's a balancing act, does it come down to the trial court's discretion? Well, our review being an abuse of that discretion.
It's not a balancing in the sense that you look at and you say, okay, we have these efficiencies, and then we have these unfair aspects of it, and okay, it's only this unfair, but it's really efficient. It's not that type of balancing. It's identifying.
What type of balancing is it then?
It's assessing whether the multi-plaintiff trial, the mass trial like in this case, creates a risk of unfairness. And if it does, an unfair prejudice, then the court abuses its discretion if it decides, well, I'm going to put those aside, or that unfairness isn't big enough to offset the efficiency. The cases are clear, consistent, that you cannot sacrifice a fair trial for some perceived deficiencies, and that's what happened here. And again, all these were presented in the motion to sever to the trial court beforehand. And to your question, Judge Odenwald, Sure.
I have a very similar question, so I think you can knock out two birds with one stone when you're answering his question. To me, the central issue is how much discretion do we give to the trial court? Our standard of review is abuse of discretion. You don't get to retry the case. So I need you to speak to why those three factors, the plaintiffs, the three factors were the basis for all these cases being tried together. How does our standard of review give us the ability to say that he's abused his discretion?
Yeah, and if I could add to that, let's just assume that we were confronted with the exact opposite, that the trial court had severed the trials. And plaintiffs here were now arguing to us that that was an abuse of discretion. And we have to apply the same standard. When do we set aside the trial court's decision based upon that abuse?
You set aside the trial court's ruling, its determination, its exercise of discretion, when the circumstances of the claims presented reflect an unfair prejudice to either party, depending on the circumstances, as they did here, to suggest that you could ever try a 22 families claims of this type in a single trial. And that could be done fairly, much less that it was done fairly as it was in fact tried in this case, frankly defies human nature and common sense, that you're going to put all these claims together and you're going to have 22 women, some still alive, some not, with claims of ovarian cancer, being tried together, and that's not going to affect how the jury views the case. Is frankly preposterous to suggest that.
Does
Mr.
the fact
Weaver?
that I'm sorry.
Go ahead.
Does the fact that 17 of the plaintiffs are filing claims under different state laws, did that really have an impact on the severance issue? Or is that something set aside just for the jurisdiction?
Well, one of the impacts of that is that you don't have identical instructions for all of the plaintiffs. There is the instructions have to reflect differences in the state laws. An example in this case on statute of limitations aspect and state-of-the-art aspect, and not everybody was submitting the same claim. I'll go back to the Blanks case, which was the lead poisoning case. Those were identical instructions given for every plaintiff's claim. That was not the case here. So it did have an impact in the sense that it was another variable that the jurors were confronted with, that it is impossible to suggest that they could have fairly considered all these evidence and analyzed these claims on an individual basis, and then the record reflects that they didn't. In a short time period, a 6-week trial, 22 supposedly separate claims, but presented as a group claim, evaluated in 8 hours over 2 days, and then returning the verdicts they returned. And Judge Odenwald, getting back to your question about the evidence and the suggestion that evidence came in that shouldn't have gotten in, for example, well, it's clearly, the difficulty here is in this case, the jury was permitted to consider evidence of all these claims together, collectively, that they wouldn't have heard had the claims been tried separately.
Well, but the evidence with regard to the expert testimony and the trials used and that all would have been the same.
Well,
I mean, that was the key of I think a lot of the objections I read in the briefs about the evidence was that, this expert testimony shouldn't have been allowed. It was junk science. But wasn't that the same for each of the plaintiffs because they used the same baby powder?
Well, they used, we're talking about a span of 50 years of use, with both with regard to general causation and specific causation. But you're talking about a span of 50 years of use, with plaintiffs using it during different time periods, when it was being sourced from different mines, and they had different periods of use, and they started using it at different ages, and they used it for different different time periods. And so even the general causation concept of this should have been individualized. There wouldn't be the same evidence.
But did the jury hear all that evidence?
But the jury heard...
It's a yes or no question. Did the jury hear all that evidence?
The jury heard all that evidence.
And was the jury instructed individually for each plaintiff, both orally and in writing?
The jury was given separate instructions for each claim, yes, Judge Hess. The difficulty is that there's no way for the jury to silo all this evidence. With an example of Miss Schwartz-Thomas, for example, who started using the products in 1985. So she never used it when it was being produced from China. When the source of it was the Chinese mines. And there was no evidence of any contamination of any talc during the time period she was using it. But what came in and what the jury heard was all this evidence from Mr. Longo talking about these historical bodies going back, the bottles, which with no chain of custody again, going back in the 30s and 40s and 50s. So they heard all the evidence, but there was no way that they can segregate or know how to segregate what evidence is relevant to a particular plaintiff's claim. Miss Schwartz-Thomas, Dr. Long or Mr. Long would have never been permitted to talk about issues regarding contamination at a time when 20 years or 30 years before she ever used it, before she ever used the product. And with regard to other aspects of the case...
Well, let me ask you this. Was a limiting instruction requested or a limiting instruction given by the trial court with regard to this evidence?
There was no, the only instruction given was that the jury would be given separate instructions to return separate verdicts for each plaintiff.
So, but let's go back to my first question. Did your client request a limiting instruction with regard to the evidence?
No limiting instruction was requested in the context I think you're meaning, but I don't know what that instruction could have possibly said. Is, for example, you have living plaintiffs. And you have plaintiffs, women who have died as a result of ovarian cancer.
We've had plaintiffs who've died while the case was pending on appeal.
That's correct, Your Honor. And you have, how do you silo? What do you tell them? That when you tell them they can only consider evidence related to their claim. Well, is evidence of a plaintiff going through, a deceased woman going through 10 years of severe chemotherapy and a very, very difficult time and then dying, is that relevant to the claim who's somebody who's still alive? Well, I think the jury's going to think it is. Look, that's the future. But you would never have been able to present that evidence in a claim in one of these cases tried individually.
Would some of this evidence have been admissible in any circumstance under the context of punitive damages and reprehensibility?
No, I don't. You would not be able to, for example, play the video deposition basically on her deathbed of Miss Packard in support of a punitive damage claim asserted by somebody, by one of the other individual defendants. The punitive damage, the constitutional limits on punitive damages preclude awarding punitive damages based on injuries to others. And that's exactly what that type of evidence would fall into. So the difficulty is that the jury cannot have been expected to silo this evidence because there's no way you can do it, and there's no instruction that you could have given that would have provided the necessary guidance. And they can't unhear it anyway. You're sitting there listening.
If I'm hearing you, Mr. Weaver, what I think your argument is it's just simply beyond the capability of a jury to look into this bowl of spaghetti and separate the strands.
It is absolutely unreasonable to assume that they can, confronted with all of this information. And as in the Malcolm case, where the court recognized that the torrent of information that was provided. There's no way they could have done it. And then the ultimate prejudice after the fact, after all of these other things, the plaintiff opening and closing with a statement, these women have two things in common. They used the talc and they got ovarian cancer. And then throughout the trial, comparing the plaintiffs. And then you have a causation expert testifying in 49 pages, giving specific causation testimony for 22 plaintiffs, where the effect of that was simply homogenizing all of the plaintiffs' claims, minimizing the differences, minimizing the difference of risk factors, and presenting a specific causation case that would have been plainly inadequate.
I understand, but then certainly Johnson & Johnson and JCCI had the opportunity to make those differences through cross-examination and to bring out the inconsistencies. I mean, it's not as if it was just all one-sided. From what I understand, your concern is that the jury just would have just set aside whatever distinctions you would have raised because there was just so much on the other. I mean, is that kind of what you're saying?
Well, we can raise those issues, but we're having to address issues that the jury should never have heard. Why should you're not starting with the scales even here. You're starting the trial with the scales tipped. And it's our burden to try to eliminate the prejudice inherent in combining this. I mean, if there was ever a case that called for separate trials to avoid prejudice under Rule 52B, if this was it. Just list the sheer number of plaintiffs from 22 families, the material variability and their risk factors, exposures and types of ovarian cancer, the contested issue of causation, the counsel's advocacy from the beginning and throughout, that the jury infer causation from the number of plaintiffs, the presentation of these claims as a collective, the way in which the evidence of all 22 families flowed together with no reasonable way for the jury to separate that, and the undeniable emotional toll of a week where 5 consecutive days where all you presented was plaintiffs or plaintiff's family coming and tossed to me. If this is not an abuse of discretion, if this didn't warrant separate trials, then I can't imagine a case that would. I want to get to a couple issues here. I see that my time is running down. I'd like to discuss the but-for causation issue. The court's failure to perform its obligation to correct counsel's misstatement that but-for causation is not the law by itself.
Well, that's not what he said. He said it was made up.
What he said, two things. He said it was not. He said it was made up. And he also said that you won't find it in the instruction.
Isn't that a true statement?
If it's, you won't find it in the instruction, that's true, Your Honor. But in White versus Gallion, that was exactly what happened. The defense counsel said you won't find, keep a careful lookout in the instruction. And the court said that that was tantamount to saying that it wasn't the law. It's right on fours with that. In the Hill case, the statement was made that you won't find anything in the instructions about spoliation or an adverse inference. And this court held that that was reversible error because it suggested to the jury that that wasn't the law.
But that's a little bit of a difference, correct? Do you disagree that this jury was improperly instructed in the instructions they took back to deliberate on? Was the jury properly instructed?
The instructions, we're not disputing the MAI instructions.
I know. Follow my question, Counselor.
I'm just having trouble hearing is all, Your Honor.
I'm sorry. I'm trying to talk loud.
Yeah, it's the acoustics.
Okay, so my question is, was this jury properly instructed?
They were given the MAI instructions.
So they were properly instructed, correct?
They were, well, the problem was they were given the MAI instructions and then told by plaintiff's counsel.
But he went back in his very next statement and corrected, and I believe his corrected statements after the court overruled your objection were correct and based on MAI, were they not?
He used the words in the instruction after telling the jury that but-for was made up, and they wouldn't find that language in the instruction.
But it's different from Hill, because in Hill, the jury had no actual adverse inference instruction to go back and look at. Is that correct?
That's correct, Your Honor.
So in this case, this is a little different than Hill, because those three words were incorrect pursuant to Callahan. I agree with you on that. But the jury had the proper instructions in front of them. Is that not correct?
That's correct. They had the proper language, but they were told by plaintiff's counsel that but-for was made up and but-for wasn't there, which White versus Gallion says that's the equivalent, that's tantamount to saying that's not the standard. They were told that the judge overruled the objection, even though it was a misstatement, of law. So they're told whatever they think caused or contributed to cause, they're going back and deliberating and applying those instructions, having been told without clarification or without correction from the court that but-for is not part of that analysis, and that's wrong, and it's coming on the heels. This comes after plaintiff's specific causation expert has testified that he can't testify as to but-for causation as to any one of these.
But he did testify that, in his opinion, it caused or contributed to cause. Did he not?
That's correct, Your Honor. He did testify that he mouthed the language.
So why doesn't but-for appear in MAI? There are cases that explain to us why the MAI does not use the phrase but-for. Correct?
Yes.
And that's because the phrase itself can confuse the jury. Because it can suggest sole cause when that's not the law in the state of Missouri.
A couple things. One of the explanations in Callahan is that the reason but-for the cause or contributed to cause is used is because it's not simply limited to a but-for causation. It also encompasses the two fires situation. And plaintiffs don't argue two fires. They agree that but-for is the proper standard, that's the standard that must be met. But the other thing to remember
But why isn't it used in MAI?
To allow a single instruction that encompasses both but-for causation and two fires. And you have to remember, in the paragraph at page 863 of the Callahan case, it explicitly says that there recognizes that there are two components to this, and to the how the jury is informed about what the standards apply, and one's the MAI instruction that the court gives, which you can't deviate from. But then the lawyers have the right and maybe the duty to explain to the jury what the instructions mean. And that's what was happening here. And
when did plaintiff's counsel make this statement? Did he do it in his initial close or in rebuttal close?
He did it at his rebuttal close.
In response to statements that have been made by your client in its argument.
That's correct. Our counsel for the defense had stated to the jury, explained to the jury, that they had to find that they had to find that plaintiffs wouldn't have gotten the cancer they got if they hadn't used the product, but for their use of the talcum powder product, which is the but-for test.
But doesn't that suggest sole cause?
No, it doesn't suggest. There is nothing in the record to suggest sole cause. But even if it had, even if there had been anything to interpret as suggesting conflating sole cause and but-for, and you will find nothing in the record that suggests that. The proper thing to do by plaintiff's counsel was, number one, object to that. Say, Judge, that's improper. Go up and they can make their record that he's improperly conflating that. And two, explain to the jury, listen, but-for may be the test, but that doesn't mean sole cause. You can have more than one but-for cause. They can combine to cause the injury. So instead, he authorized, I mean, he misleads the jury about what the standard is, and then and impugns the integrity of defense counsel by suggesting that he's making up a standard that everybody agrees, including the plaintiffs, is the standard for causation. And case after case in Hill and White state that misstatement of the law during closing argument is impermissible. It's not a matter of discretion to correct it, that the court has a duty to correct it. And in the Halford case, the court also makes clear that overruling an objection to a misstatement of law is almost always inevitable error. Subject to...
Can you please move on? You've got 2 minutes. Can you please move on to this issue of jurisdiction?
Yes, that's what I...
Particularly J&J jurisdiction?
That's where I was headed, Your Honor.
Great minds think alike, Counselor.
Plaintiff's basis for personal jurisdiction over J&J rests solely on the contracts that JJCI, its subsidiary, had with Pharmatech, which was a Missouri corporation, for the manufacture of a glittery product, shimmer, for a 2-year period, or for a 4-year period. And then JJCI also had contracts that involved the the manufacture of Johnson's baby powder in Georgia. Johnson & Johnson was not a party to any of those contracts. Plaintiff doesn't claim that Johnson & Johnson was a party to any of those contracts. There are no connection, as required by BMS, as required by Fox and Risteson. There is no connection between the activities of Johnson & Johnson and Missouri out of which any of plaintiff's claims arose. And plaintiffs, the only possible way that they could have obtained jurisdiction over J&J based on any contacts that JJCI had with Missouri would have been to attempt to establish either agency or that there was an alter ego relationship. Plaintiffs never presented anything suggesting either agency, as this court addressed in blanks, the factors laid out in there, or alter ego. So there is absolutely no basis under Missouri law for holding making Johnson & Johnson subject to the personal jurisdiction of Missouri, based on the contacts between JJCI and Missouri, even if you conclude that those were adequate contacts to exercise jurisdiction over JJCI with regard to the claims of the non-residents. So all of the 17 claims against Johnson & Johnson by the non-residents should be reversed and vacated. All of the claims should be vacated based on the 2 issues we previously discussed. And then even if you conclude that there's adequate basis for jurisdiction over JJCI with regard to the non-resident claims, again, there are two plaintiffs who don't ever claim to have used shimmer. So those judgments would have to be vacated as well. I see that my time is up. Thank you.
Can I ask you one more?
Go ahead.
Mr. Weaver? Mr. Weaver? One more question for you.
Sure.
The legal file in this case is daunting, to say the least.
Yes.
I looked repeatedly. I'm trying to find an order where Judge Burleson denied your jurisdictional claims on J&J or JJCI. I can't find that order. Was there an order setting forth his reasoning for not granting the relief you requested?
As to Johnson & Johnson?
And or JJCI?
Yes, there is, and I have it at the table, and I can give you where it is.
You'll have 30 minutes to find it.
Yeah, if you could just give us that, I would be very appreciative.
Yes, there was an order entered on the personal jurisdiction issue that arose out of the shimmer. The people were suddenly remembering using shimmer.
Well, and again, I'm pretty sure that once you give me that number, I'm going to be like, oh, I think I looked at that, but I missed it. So thank you.
Sure.
Thank you, Mr. Weaver. Mr. Parker, we're going to clean up, and then it will be your turn.
Good morning, Your Honor. May it please the court. In light of what we've heard just now, I'd like to spend my time addressing 3, possibly 4 issues. I'm going to talk about joinder, jurisdiction, a minute or 2 on but-for causation, and if we have time, I'd like to address the constitutionality of the punitive damages.
Counselor, I would suggest you start with the constitutionality of the punitive damages and explain how the punitive damages do not punish J&J for conduct toward non-parties in this case, specifically.
Your Honor, they don't, because their argument regarding that has to do with a dollar amount spent by J&J. I mean, their argument regarding punishment of non-parties is that the jury assessed punitive damages based on Todd True's email about revenue. That's not a claim against the third party. The jury assessed punitive damages based on the evidence in this case about what Johnson & Johnson did with the powders as it affected these plaintiffs. And so, yes, there is a nationwide story, so to speak, regarding asbestos in the talc, how they knew about it, how they sold it, and all that evidence is relevant and proper for the jury to consider on the reprehensibility question. But when it comes to the assessment of the damages, that all ties in to the talc that these ladies took for decades and decades. And so it's a punishment for what Johnson & Johnson did to these 22 plaintiffs, not regarding other parties' claims. The concern, the constitutional concern regarding not punishing somebody for claims of third parties is those third parties aren't in the courtroom. Those claims really aren't in the courtroom. The defendant is not really defending against those claims in the courtroom. That's not the case here. In this case, the punishment related to what the evidence showed Johnson & Johnson did and how it affected these ladies. All the parties were in the courtroom, so I don't think we have a problem regarding the issue of the punitive damages punishing for third-party conduct.
I think we're having a technical issue.
Should I continue, or would the court like me to stop?
Let's just take a brief pause.
Okay.
I'm watching your time, Counselor.
Thank you.
Okay, you may proceed.
Your Honor, would you like me to continue to address punitive damages, or have I?
You've answered my question sufficiently.
Okay, thank you.
We also need to add a minute onto his time. Thank you.
Your Honor, let me then turn to the joinder question.
It's really a question of severance, right? I mean, the motion was to sever these into separate trials.
That's right, Judge Odenwald.
And so we are then bound by the standard of review in reviewing that type of motion, which is abuse of discretion.
Correct.
Okay,
Correct.
and it was raised under Rule 5205. Rule 5205. And I guess the question I have, I realize that rule gives a lot of discretion to the trial court. The trial court may order separate trials or make other orders to prevent delay or prejudice. It would seem that it would be challenging. I'm not going to say impossible, which is the appellant argues that it's an impossible task for the jury to have done all this. But would you agree that there was a challenge here for jurors to really separate and consider each individual case? Because the jurors do have to render a verdict on each individual case on the merits of just that case. Would you agree that that was a pretty daunting task, given the nature of this case, not just the fact that there's a multitude of plaintiffs, but you have 17 plaintiffs from different states, different state laws, different types, different periods in which they contracted, different levels of recovery? That, to me, wouldn't seem to be very easy.
It would be challenging, but we had a well-instructed and highly attentive jury in this case. And
I understand you, well-instructed jury. Jury instructions were read for 5 hours. And that in and of itself, to sit and to listen to somebody read for 5 hours, I really wonder how much is taken in.
Of course, they did have to sit and listen to 5 hours of jury instructions, but that misses the point that they had a copy of it. Each juror had a copy of those instructions.
I understand.
As they went back to the jury room.
And then how long did it take them to reach a verdict on all 22 cases and come up with the amount of damages and punitive damages and all that consideration for each of those 22 cases?
I think it took them 9 or so hours, Your Honor.
9 or so hours, okay.
And so, as Judge Hess indicated, we cannot assume that because the challenge, or because the task was challenging, that they were overwhelmed, because...
Well, I agree, and I note that the appellant raises the issue that they were identical damages. They gave the same identical damage to each of these, and there were different circumstances, and that in and of itself should be some indication of the prejudice that the trial court should have been aware of or should have taken into account. How do you address that? Because that does seem like, 22 people who have suffered for years and years, people who have recovered, the loss of consortium, yet everyone got the same. The pie got split equally. And I'm not so sure that reflects reality.
I would address that issue by turning first to the Court of Appeals decision in the Elam case, a case involving, I think, 32 different plaintiffs with different claims. In that case, the defendant made an argument very similar to that made by the defendant here, that identical jury verdicts are per se improper, and the Court of Appeals rejected that argument as rigid logic. And more importantly, the Court of Appeals challenged whether an appellate court could really go behind what the jury did and question their calculations or say they misconceived the evidence.
No, I agree with you with what the case says. Identical verdicts in and of themselves are not sufficient. Identical verdicts isn't going to be the litmus test. But it seems here that it is a factor, and when you include that with everything else, the complexity of the case, the different states, the different laws, that maybe this isn't just identical verdicts that should have band-aided severance. Maybe but that identical verdict is just one piece of the puzzle that should have been included when making that decision.
I disagree, Judge Odebog. I agree that identical verdicts alone is not enough.
I thought you'd agree with that.
Yeah, that's the clear teaching of the law. But when we hear the defendants talk about differences in the law of the different states, nobody expressed confusion about that in this case. There's nothing in the record where the defendants argued before the jury in closing argument about different states' law meaning different things. The jury didn't ask questions, and the jury was properly instructed. There's no challenge in this appeal that the jury was not properly instructed. And so they had the separate verdicts in front of them. They had the questions, and they answered them. Regarding the evidence, we heard some discussion by my friend about different evidence coming in from talc mines at different times. I think he actually referred to Miss Schwartz-Thomas, but Miss Schwartz-Thomas used Vermont talc just like every other plaintiff did. She didn't use Chinese talc, but she used Vermont talc. In fact, all of the plaintiffs used talc from Vermont, and all but one from Italy, and all but two from Italy, and all but one but China. So that really overlapped, and that's the key to the analysis of severance. They asked for 22 separate trials, which would shut down the courthouse or the division of the circuit court for well over a year. And the case law teaches us that when you have, especially in toxic tort cases, when you have overlapping issues, then consolidation or joinder of these claims is proper. This was a 6-week trial. 5 of the 6 weeks dealt with common issues. 14 witnesses, expert and otherwise, dealt with common issues. And so this was a proper case for consolidation. It raised the efficiencies by manifold factors. Further, regarding their fairness argument, the circuit court judge knew, having tried these cases before and having been familiar with this case, knew that these ladies were dying of cancer and that they needed to get to the courthouse as soon as they could.
Mr. Parker, let me ask you, I appreciate everything you've said. How do you respond to the appellant's argument that as a result of the combination, the joint trial of all these 22, that you ended up with a substantially higher verdict than in the prior talc cases that had been tried in the city of St. Louis, basically with the same arguments, and you're aware of those. I mean, this was substantially higher, and that seems to be one of the concerns that was raised as to why severance would have been appropriate. And perhaps you're correct. I guess if the motion was just to make it into 22 separate trials, maybe there could have been a motion to group the plaintiffs in different groups so that you had smaller groups, but you still didn't have 22 individual. But the damages, the $25 million, is greatly in excess of the prior trials for the same cases in the same jurisdiction in the same city court.
Two bases for a response. First of all, you're right. They didn't request any groups until 11 days into trial. They did at that point, after we tried the case for 11 days. Regarding the amount of the compensatory damages, first, they're not challenged here. There's no challenge by the plaintiff or by the, Johnson & Johnson that these were excessive damages.
But do they have to? When they're not challenging it as excessive, they're using that as an indication, say, why trying these cases together was unfair, because the cumulative effect just naturally brought the damages up. I mean, so that's a distinct legal argument, is it not?
Judge, I think if they're going to say the damages were too high, they have to make that a point on appeal, and they haven't done so here. And I would also say that the whole argument about the identity of the damages, again, violates the principle we learned from Elam and the Baumla Supreme Court case, that we're not to take the innermost thoughts of jurors and put that on the slide for judicial examination, and that's what they're asking. Regarding, let me make a couple more points regarding joinder. Regarding commonality, Mr. Lanier argued in his closing argument that each of these women were drawn into a damages swamp, and he had a PowerPoint slide listing all the common things that they'd experienced: sleeplessness, chemotherapy, surgery, telling their family. And he explained to them how the damages were similar to each other. These women all faced a life-halting, life-lasting, life-ending disease of ovarian cancer. So it's not surprising the jury could hear that testimony and come up with the same amount. On the other side of the docket, the defendants didn't say anything in closing argument about some plaintiffs should get more or less. They left 15 minutes on the table and didn't say anything about it. So their argument today sounds like a little bit of Monday morning quarterbacking because they're talking about problems that they didn't address at the time. This was a well-instructed jury. They were not a group of people who were overwhelmed by this. The court can look at their backgrounds. There was financial analyst. There was a scientist from DuPont on this jury. There was a computer game designer. There was a juvenile city officer. These people took their task seriously, and the court should not just assume that they were overwhelmed. This case involved common issues. This was an ideal case for consolidation. It was challenging, but Judge Burleson, who tried these cases before, knew the experts and knew it could be done, and it was done. So we think the court didn't even come close to abusing his discretion and denying their motion. And remember, the court has to find for discretion to be abused that the ruling was against the logic of the circumstances and was essentially arbitrary and capricious. We're not here. Judge Burleson correctly followed this state's policy in favor of joinder. Your Honor, I've got just about half my time left. I want to spend a few minutes on but-for causation, and I want to address jurisdiction as well. So let me turn to those issues, if that's all right.
When you start your but-for causation, Counselor, can you clarify the standard of review? I'm having a hard way to go with the standard of review, and it was not clear to me from the briefs exactly how we review this question.
It's a confusing question, standard of review on this case, and something we've thought a lot about too. I think the question of whether Mr. Lanier was making a factual statement or whether he was responding to a misstatement by counsel or making a misstatement of the law, I think that's an abuse of discretion standard. And the reason is because you need context to understand what counsel were saying. As far as if the court finds he misstated the law, then I think the court's discretion is narrowed. Prejudice still must need to be shown, but if there's prejudice there, the court should issue an instruction. But the issue here is whether Mr. Lanier misstated the law. And I think, Judge Page, you raised the point. It may have been you, Judge Hess, I'm not sure, during counsel's argument about responding to the comments of co-counsel. And Missouri case law is very clear that if counsel gets up and makes an incorrect statement, then responding counsel is entitled to do that. And what Mr. Bix did in his closing argument on page 6081, I think, stood up and started talking about the verdict director. And then he said, this requires that the plaintiffs show that but for their exposure to Johnson & Johnson talc products, the injury would not have happened. And while he was doing that, he had a PowerPoint slide on the screen where but for was in quotation marks on the slide, giving the impression that but for was in the verdict director. But it wasn't in the verdict director. And what Mr. Lanier did was he got up and he corrected that. He said, it's made up. It's not in the court's question or the court's charge. And what he did was properly return the jury to the question they were actually asked, whether directly caused or directly contributed to cause. And that was entirely proper conduct. Now let me turn, Your Honor, to the issue of personal jurisdiction. And I do want to address your question, Judge Page, regarding the jurisdiction over J&J, and I will get to that in a moment. But I'd like to just, by way of context, address the issue of jurisdiction over JJCI. There are three arguments for jurisdiction. First, as to the 5 Missouri plaintiffs, they bought and used their talc here. There's no dispute that the court had jurisdiction over them.
That's the easy one.
That's the easy one, right. Second, all but 2 of the plaintiffs used a J&J powder known as Shimmer, which was manufactured by a Missouri corporation in Missouri.
So what about those 2 plaintiffs who did not use Shimmer?
They fall into the third argument of jurisdiction involving the long-term contractual relationship between JJCI and Pharmatech Industries, a Missouri corporation, that resulted in the manufacture of Johnson's baby powder. So I'm going to address that one as well.
But where was that powder manufactured?
The powder was manufactured in Georgia. But the contract to manufacture the powder was between JJCI and this Missouri corporation. And the contract specifically said, we are choosing you, Pharmatech, because of your unique attributes and experience. It specifically said the obligations under the contract were personal to the Missouri corporation. It said further that if the Missouri corporation assigned its obligation to a related company, which they did here, then the Missouri corporation would remain fully responsible to guarantee the performance and to perform the obligations under the contract.
But it's incumbent to show a connection, a particular connection of the plaintiff injuries to Missouri. And so the baby powder, Johnson's baby powder, was never manufactured in Missouri. The only thing that was manufactured in Missouri for a short period of time was this Shimmer.
That's right, Your Honor.
So I'm struggling with finding somebody buys baby powder in Georgia or Florida or anywhere else. That baby powder was manufactured out of Georgia, never in Missouri, even though the parent company or an affiliated company is located in Missouri and made a contract. I'm struggling to find the connection that the Missouri Supreme Court requires of us in Bristol. Myers.
In the Burger King versus Rudowitz case, the Supreme Court recognized that ongoing contractual relationships are sufficient to create jurisdiction. In other words, if somebody reaches beyond state borders and creates a long-term contractual relationship with another party, that can be a basis of jurisdiction. And that's what happened here. It
So
was
JCCI has a contractual relationship with Pharmatech in Missouri.
Yes.
Okay, and as a result of that contractual relationship, Pharmatech has some affiliated company in Georgia producing baby powder.
Pharmatech is responsible and obligated to produce the baby powder.
But who's actually producing the baby powder?
A related family
A
company.
separate corporate entity, correct?
Yes.
Okay, which is a separately legal entity, and there hasn't been any evidence, as I understand from the record, of alter ego in which you can combine these, you can ignore the distinction of the corporate entity. That's the struggle I have, and again, and I'm struggling from a point of view of what the Supreme Court has pretty emphatically stated with regard to, this connection and specific jurisdiction with Bristol-Myers, and then the Missouri Supreme Court with Fox following up on that.
Let me address Bristol-Myers with respect to the baby powder contract and with respect to the Shimmer contract. The baby powder contract, again, it was a contract with the Missouri Corporation. They were obligated to perform it. They performed it in a different state, but they were obligated to perform it. And it was long-term. It was ongoing. It involved buying talc and inspecting it and selling the product.
And that was the contract between JCCI and Pharmatech.
Yes, it's called the Manufacturing and Supply Agreement. It's in the record. With respect to Shimmer, that's admittedly an easier question because Shimmer was actually manufactured in Missouri. And that's what makes this case different from Fox and different from Ristison and different from BMS. In Fox and Ristison, the court, as you know, Judge Odenwald, didn't have the Shimmer PTI evidence before it. In BMS, the Supreme Court specifically noted in not holding jurisdiction that the product was not manufactured in California. Here, it was manufactured in Missouri.
But you're talking about Shimmer's manufactured in Missouri, but what I'm asking about is those defendants, or I'm sorry, those who you tried to get jurisdiction over the baby powder, not Shimmer and Shimmer, and the baby powder was never made in Missouri. The baby powder, these plaintiffs never purchased it in Missouri, and they never came to Missouri, and that powder wasn't manufactured here. It was manufactured by a separate corporate entity in Georgia, and so that's where I'm struggling. I'm not saying I'm lost on the issue, but those are the challenges that I see.
It was jointly manufactured by the Georgia entity and the Missouri entity. The Missouri entity was fully responsible for the manufacture of that product.
Physically, actually, who did the manufacture? It was PTI Royston in Georgia.
It was in a plant in Georgia. Regarding Shimmer, though, it's a completely different case because of the manufacture in Missouri. And let me turn quickly, Judge Page, to the J&J argument, the parent company argument, before I move on to my final points. Regarding J&J, I would invite the court to put itself in the shoes of the circuit court judge here. He had hundreds of pages of briefing in front of him regarding motions to dismiss. There were 4 or 5 filed. There were over 20 pages apiece. A lot of them were cut and paste work, but there was a lot to read. The J&J corporate separateness argument was raised in a couple of footnotes that kept popping up in the different briefs with no evidence except for a hearsay affidavit. And is it fair to reverse a circuit court judge for not ruling on an argument that's only brought up in a footnote? And I would suggest they waived it by not putting it in the text. And we've cited cases in our briefs that have recognized that if you're going to bring up an argument just in a footnote, that's not really bringing it up.
Okay, let's go past the footnote issue.
Okay.
Let's assume that it wasn't waived. Let's address the substance of your argument.
The substance of our argument is that J&J reached into this relationship between JJCI and Pharmatech to impose its corporate desires. it required Pharmatech to follow the J&J corporate policy regarding contractors, which related to the quality of the production of this powder. It required J&J and its contractors to follow the J&J credo, which is their sort of mission statement. That was contractually inserted in this contract, and the contract itself says these are policies of the J&J family of companies.
And who imposed those policies on Pharmatech? JCCI. I mean, that was the contract was just between JCCI and Pharmatech.
That's correct.
Okay.
But J&J,
Okay.
they're in there because of J&J. Further, the manufacturing supply agreement provides an indemnity to Johnson & Johnson, the parent company.
Was there evidence brought at trial that these inclusions in the contract were required by J&J?
No, Your Honor, not in the trial.
So we're assuming that. We're assuming that because they're in the contract, J&J must have required them as opposed to JCCI imposing them themselves.
You can look at the policy in the contract, and the policy itself refers to the company contractor policy. I may not have my wording exactly right. Imposed or applicable to the J&J family of companies, which suggests it comes from above.
Okay,
And you don't know.
But how does that, there's two ways to get to home base. Alter ego or agency. The fact that there's some control by a parent company of a subsidiary is not enough. That's pretty clear in the case law. So what you're saying, how does that establish one or the other, alter ego, complete domination and control, or agency? That's what we have, that's the lens we have to use.
I understand, Judge Hess. It establishes agency because Johnson & Johnson is using its agent, its corporate subsidiary, JJCI, to include these policies that Johnson & Johnson wants in place in this contract.
What evidence was there of the agency relationship? Again, they're separate corporate entities. Was there some sort of manufacturing agreement between the two that was introduced into evidence? I mean, the mere fact of a parent-subsidiary relationship in and of itself does not prove agency.
That's right, Your Honor, but in this case, Johnson & Johnson was using its agent to put its policies in the agent's contract. These were Johnson & Johnson policies.
What evidence is there of that? You're assuming that from the fact that there are certain things in the contract?
I am assuming it from the documents themselves, which say they're Johnson & Johnson policies.
Do you know if all Johnson & Johnson affiliates had to use those policies?
I don't know, Your Honor.
And there is no evidence of that. That's the struggle I'm having with regard to the jurisdiction over the J&J.
Yeah, okay.
So with regard to agency, what are the essential elements to establish agency?
I think you have to have communication by the principal that the agent is acting with the authority of the principal.
That's one of them, but there's a couple more.
Well, there's a parent agency where you can tell it, where the person dealing with the principal can tell from the conduct, or the person dealing with the agent can tell from the conduct of the principal that that they have authority. But I think that applies here. Again,
but in that case, the conduct has to come from the presumed principal. So Johnson & Johnson had to have done something to let the third parties know that JCCI was its agent. That's a parent authority.
Yes.
And so what is it that J&J did that would make third parties think that JCCI was its agent?
This is the evidence we're relying on, and let me just, to answer that question, we look at the documents themselves that refer to the J&J family of companies. There's nothing else. And so if the court is trying to find what to look at, that's it.
That's where you're directing
us. Yeah, okay. Yes. Your Honor, let me spend a final minute going back to the question of punitive damages. And this time, I want to address the ratio question. As the court knows, the record is replete with evidence of reprehensible conduct. Making baby powder with asbestos in it, selling it for decades to babies or to their mothers and to young women. Lots of reprehensible conduct. But their argument is the court has to impose a 1-to-1 ratio because of State Farm. This case, we have a ratio of 1.8 to 1 with one defendant and 5 point something to 1 as to the other. Our position on that issue is certainly a 1-to-1 ratio would be a reasonable finding. But based on the reprehensibility here, this court under Pogue and even under State Farm, which says 1-to-1 is not a rule, has the ability to reduce the damages to amount between the jury, between what the jury found and the 1-to-1, or award the full amount. This case is replete with reprehensibility.
So is there a limit? I mean, where do we take that?
If there's a limit, it's 10 to 1. I mean, the law is more clear that 10 to 1 is the limit.
The law is very clear with regard to 10 to 1 when you don't have a very large compensatory damage. So I mean, so you would say that's the outer limits of due process requirements.
Right.
Okay.
And if I may just finish up on that point, this court in the Pogue case said there's not a 1-to-1 rule. Take it on a case-by-case basis, look at the circumstance, and that's what we'd ask this court to do.
Thank you, Mr. Parker.
We'd ask the court to affirm. Thank you.
One final question.
Oh, yes.
Do you have any talc cases that have been affirmed on appeal with comparable punitive damages?
Not that I know of, Your Honor.
Okay, thank you.
Thank you.
Mr. Weaver?
Thank you. Judge Page, the personal jurisdiction order is at D4049. That also appears in the appendix at page of our brief at A190.
A190?
A190.
Thank you, Counselor.
Yeah.
We knew we could count on you.
And thank you for putting it in the appendix.
Yes. I can't take credit for that, Your Honor. Just dealing with some personal jurisdiction issues quickly. Again, Burger King, which counsel cited, still requires the claim to arise from the activities that cause the injury. There are general references to J&J standards, but if you look at the documents, the only specific reference to J&J, meaning Johnson & Johnson, is in the notice provisions of those agreements. And in a number of those agreements, J&J is specifically identified as referring to JJCI because they shorten it in the introduction.
Well, Mr. Weaver, what about Mr. Parker's argument that perhaps Johnson & Johnson has waived this issue by not bringing it to the forefront in front of the trial judge?
In responding to the post-BMS basis for jurisdiction, the plaintiff's basis was contracts. We always emphasized throughout, as cited in our brief, that Johnson and those contracts were with JJCI. It was clear from the filings that we had that the contracts were with JJC. That was the basis for it. Yes, we announced that J&J and CI and Johnson & Johnson were separate corporations, and that was all that was necessary to establish that. They weren't making an alter ego argument. They weren't making an agency argument. They were separate corporations. They pleaded them as separate corporations. The three elements of Judge Hess of agency under Missouri law are fiduciary relationship. The agent must be able to change the legal relationships of the principal, which they couldn't do here. There was no showing. And an element of control, which also didn't exist here. I'll refer the court on the citations where personal jurisdiction was addressed. That's D3243, pages 2, 9, and 12, D6080, page 9, and D5 691, all those legal file documents, and also the pretrial transcript, which is pages 34 to 41, where, again, the difference between J&J and JJCI is discussed. Judge Hess, in response to your question earlier about the explanation, again, not only does Callahan recite it, but the MAI contemplates that the juries will be, the lawyers will be explaining the meaning of the instructions as long as it's consistent with the law, which when you review the record, you'll see that's what happened. And so the jury is given the impression, again, through improper statement by plaintiff's counsel, that caused or contributed to cause does not include but for, which was a problem with Dr. Felsher's testimony, who mouthed the words but couldn't say that they would have gotten the cancer even if they hadn't used the product, but for their use of the product. So he either didn't understand the instruction, didn't understand what those words meant, and then that ended up being communicated to the jury. I misspoke with regard to Schwartz-Thomas. The place where she got the source of the talc that she used was Italy, not China. China was subsequent. So you have evidence being introduced about contamination in a talc from Italy that she would never have used. With regard to the but-for standard of review, Judge Page, it is clear. I'll refer you to if you conclude there was a misstatement of law, which there plainly was, because he said but-for is not the law. White says that a misstated law affords no leeway for the exercise of judicial discretion, and the court is required to prohibit or correct the improper statement. Hill says the same thing. Langdon says the same thing. The Callaway case, which plaintiff cites, where there was no objection made, the court says certainly had a statement been brought to the attention of the trial court, some corrective action would have been mandated. And again, the Halford case says that when an objection to a misstatement of law is overruled, it is reversible error is almost inevitable. The Elam case, which counsel cited, there was no objection to joinder in that case. In fact, the defendants requested that the claims be presented together.
Mr. Weaver, what about the, I may mispronounce this, Minzy case, citing Peterson, that says even if counsel misstates the law in closing argument, as long as the trial court properly instructs the jury, we will rarely find reversible error. That's based upon prejudice.
That's inconsistent with the cases we've cited. And we're talking about a misstatement of law going to the core issue, the hotly disputed issue of causation. And if prejudice doesn't arise from telling the jury that the plaintiff's burden is less than it is, then I don't know where prejudice would come from. And a couple things with regard to joinder, if you could indulge me for 1 minute. I just would like to give you some citations that indicate the plaintiff's repeated efforts to treat these cases as a single claim. Transcript page 766, again, that's they have two things in common. Transcript page 5980, and then the following four citations are all circumstances where the plaintiff's counsel, when questioning one plaintiff, expressly referred and compared them to another plaintiff or one or more other plaintiffs. It's transcripts 2647 to 50, transcript 2982 to 83, and transcript 2875 to 76, and finally transcript 35 to 93. The final thing,
Mr. Weaver,
yes.
You are out of time.
Good try.
I will conclude as I walk away from the podium. The plaintiffs have cited no standard for joinder for an exercise of discretion under 5205B that would put any cap on the number of plaintiffs that could be joined in a case like this. If you have the same product and the same injury, it doesn't matter because no individual characteristics matter. And that cannot be the standard, and yet that seems to be the standard that was applied here because they haven't identified any similarities among these plaintiffs other than same product, same disease. Thank you. We ask for the relief requested in our brief. I appreciate your time.
Before we conclude, I do want to take a brief moment. Today is the last live oral argument that our court administrator will be our court administrator. Doug Bader retires in a week, and he's worked at this court for 40 years, and I wanted to give him this recognition. Also, I don't know when or if I'll see Mr. Weaver again, who keep telling us he's inching his way to retirement. So if I don't see you again either in this courtroom, Mr. Weaver, it's been a pleasure. The case will be taken under submission.